And my lord, I'll just point out, my lord, 7 points I have to assist your lordship with. And my lord, first I'll narrate, my lord, those 7 points. And your lordships would find, my lord, most of them are not, my lord,
You confine to
governor.
governor only.
Yes, my lord, governor. But that's why I wanted to inform my lords that these are the 7 points I will be dealing with.
સાચું એક કલાક લેવાનું હું.
Perfect, my lord. That's
વરના
yes, my lord.
બેસી જવાનું.
Yes, my lord. I would not taste your lordship's patience.
Mr. Sibyl, now you must tell Mr. Sibyl what my learned brother told you. Because I think my brothers
I not say that 1 hour means the actual 1 hour.
Actual 1 hour.
But
Otherwise,
tell him the last part of what my learned brother said.
Thereafter you have to sit down.
I said, see, told him in Gujarati, so that straight away the message can go.
In letter and spirit.
Later and
Otherwise, in English, it's only letter which goes. The spirit is not translated.
No.
My lord, the first point I'll make is, my lord, the objective material which the Honorable Governor has considered. Second, my lord,
1 minute.
my lord, I'm giving the proposition note. Your lordships may not write down right now, my lord.
Sometimes very good to write or type. You know why? That keeps the judge's audio sensory perception a little quiet, because otherwise you tend to talk and then eat up a lot of time. So when you're typing, you let the lawyer talk. Thank you.
I mean, when I was a young lawyer,
You are still a young lawyer.
thank you very much.
I would.
Thank you very much. Whether it's in Justice Chandrachud's court or Justice Bhagwati's court, the kind of dialogue that used to go on was unbelievable. The judges used to talk because the judges used to express themselves to actually seek answers. And in fact, when judges don't talk, it's very dangerous because we don't know what.
I always felt when I was a lawyer that if you have a judge who's quiet, it's a very dangerous thing. You never know what.
You never know. So we can't even clarify what's in his mind. So it's good wherever
the trouble is very often now with this live tweeting, people don't realize that what is said in the court is not what
Exactly.
about a matter.
Exactly.
It's only to elicit the
Exactly.
the response of the counsel.
And they misinterpret things. So
And ultimately, you look at the holistic perspective of the matter. There may be a little point here against a
Of
counsel,
course,
a little
of
point
course.
there against a counsel.
Then,
You can never have a 100% case in favor of one party or the other. Those are rare cases.
right.
Lord, that my lord tend to make the lawyer argue additional points, thinking that this might be in the mind of
No,
the
see, the
honorable
enunciation of the law has to be through a dialogue. It can't be any other way.
Sometimes the questions are asked to get the answer, so that we can also know what is.
Absolutely.
Suppose we are in confusion.
Yes,
Suppose.
absolutely,
Get some
absolutely,
answer.
absolutely, my lord.
So the first point is the objective material.
Objective material, my lord, which is considered. Second point, the submission of the petitioner that 10th schedule has a direct correlation with the governor's exercise of power under Article 174. And I have to wait. When I say I, my lord, I'm sorry, I represent the Honorable Governor has to wait till the Speaker decides.
So the argument that the 10th schedule has a direct correlation with?
No, that's their argument which I'll deal with.
Yes.
That Governor is not concerned with 10th schedule or the consequences flowing therefrom. That's, my lord, my respectful submission
You're
on
saying
law.
the 10th schedule has a direct relationship with the power of the governor.
Yes.
No, it doesn't have, he says.
It doesn't have the power.
He's dealing with the argument of
It's
the
their
other side.
argument. Yes, my lords are right. It's their argument.
That's right.
And I'm dealing with
Yes.
that argument that Governor is not concerned with the
Correct.
consequences contemplated in the 10th schedule. Lord, the other side relied upon, I'm sorry,
Yes.
the other side relied upon,
Third point now.
third point, my lord, but it is a subcategory of this very point.
But we'll take it as 3.
Your lordships, yes, your lordships would recall the other side relied upon heavily on para 397 of Bomai to show that no, 10th schedule and governor, you cannot say that there is no correlation. But I will point out that that was in a context and completely different context. In fact, on the proposition whether 10th schedule has anything to do with the governor's exercise of power under Article 174, the real judgment is Rameshwar Prasad. I'll read only few paragraphs, my lord. I have earmarked and I'll not repeat, my lord, any other thing. The next point which the petitioners urged
Yes.
was the governor should have required the, Lord, my learned friend's side to move a no confidence motion rather than directing a floor test. Lord, next point is, Dr. Singhvi, my lord, raised this point, and in my respectful submission, squarely covered by Shivraj Singh Chauhan, my lord, that power under 174 to conduct floor tests can be exercised only when the government is formed for the first time and not subsequently. Lord, that is dealt with by your lordships, my lord, in Shivraj Singh Chauhan. It was argued in the same zeal, my lord, with which it was argued here, and it is dealt with. And that's a good law, my lord. That's my respectful submission. And last, why did the governor invite Mr. Eknath Shinde and not interacted with the party or the president of the party as to whom should I invite? So these are the propositions, my lord, and I'll be as brief as, my lord, I can be, my lord, under the facts of the case, my lord.
Only 5 propositions.
These are five
Yes,
propositions.
Six propositions. my
Six.
lord. One is-
Sub-
Lord, so far as the objective facts are concerned, Lord, I have filed a compilation. It's a very short compilation. Documents your lordships have seen,